ready na for our final coverage. Right, so let's start. Mock board examination on criminal procedure under the topic bail at saka right of the accused. Okay? 25 katanungan ang susukat sa ating academic preparation pagdating sa mga topic na ito, at later on yung mga kasagutan makikita nyo sa ating description. So right, so let's start from question number 1. Okay? It is the right of the accused to have a subpoena issued in his behalf in order to compel the attendance of witnesses. So anong klaseng subpoena ang nagpo-compel sa isang witness para mag-appear? Letter A, subpoena duces tecum. Letter B, subpoena ad testificandum. Letter C, subpoenatecum duces. Or letter D, all of them. Okay, so that is question number 1. Let's proceed to question number 2. Right of the accused to be present and defend in person by counsel at any stage of the proceeding. So anong ibig sabihin ng any stage of the proceeding? It is from letter A, arraignment to appeal of judgment. Letter B, custodial investigation to appeal. Letter C, preliminary investigation to judgment. Or letter D, arraignment to promulgation of judgment. Let's proceed to number 3. Kung masyado tayong mabilis, mag-backread na lang kayo mamaya. Question number 3. If the accused pleads not guilty, arraignment and pre-trial should be held within how many days from the time the court acquires jurisdiction over the person of the accused? Letter A, 10 days. Letter B, 15 days. Letter C, 25 days. Or letter D, 30 days. Question number 4. If the other party had the opportunity to cross-examine the witness before he died or became unavailable of his testimony. Okay. Letter A, cannot be used as evidence. Letter B, can be used as evidence. Letter C, conditionally accepted in court. Or letter D, considered as void. Question number 5. The following are the remedies available to the accused whose right to speedy trial has been violated, except letter A, file a motion to dismiss on the ground of violation of right to speedy. Letter B, file for mandamus to compel a dismissal of the information. Letter C, if he is restrained of his liberty, file for habeas data. Or letter D, ask for the trial of the case and move to dismiss. Yan. That is question number 5. Remedies available to the accused when there is a violation to the right over the speedy trial. Okay? Ang hanapin nyo dito yung exemption. Next, number 6. Okay, ako hindi na makita, no? Okay, I will just read. An accused or witness invoke the right against self-incrimination if he is asked about past criminality. Okay? So, mali pala yung pagkakabasa natin. Ayun. So, yan. So, ulitin natin. Question number 6. Can an accused or witness invoke the right against self-incrimination if he is asked about past criminality? Which of the following answers is wrong? So hanapin nyo dito yung maling kasagutan sa naunang katanungan. Letter A, if he can still be prosecuted for it, question about the past criminality are not covered by the protection against self-incrimination. So siya ito na maingay sa labas. Letter B, if he cannot anymore be prosecuted for it anymore, he cannot invoke the right. Alright, so that is letter B. Letter C, if he can still be prosecuted for it, questions about the past criminal liability are still covered by the protection against self-incrimination. Or letter D, all answers are correct. Ang katanungan number 6 is can. Okay, can an accused witness invoke the right against self-incrimination if he is asked about past criminality? Okay. Number 7, suppose that X was a witness in a judicial proceeding. The counsel asked him about his whereabouts during a certain day. X was actually together with a woman in a motel during that day. Excuse me. Revealing his whereabouts would result to a domestic turbulence. Okay? Can X rightfully invoke his right against self-incrimination? Letter A, yes. Letter B, no. That is number 7. Let's proceed to question number 8. This right covers testimonial compulsion only and the compulsion to produce real or physical evidence using the body of the accused. Letter A, right against self-incrimination. Letter B, right to counsel. Letter C, right to be present in trial. Or letter D, right to due process. Question number 9. Accusation is synonymous to guilt conviction. Wait, I will read it again. Number 9. Accusation is synonymous to guilt. Yeah. Conviction should not then be based on the strength of the evidence of the prosecution and not the weakness of the defense. Letter A, true. Letter B, false. Accusation is synonymous to guilt. Number 10. Naulit. Okay, so the same question, number 9 and number. Let's proceed to number 11. Accused has the right to be present and defend in person and by counsel at every stage of the proceedings from arraignment to promulgation. What kind of counsel is referring in this statement? Letter A, competent counsel. Letter B, independent counsel. Letter C, competent counsel. Or letter D, effective counsel. Okay, pareho yung A at C. Kaya kung ito ang napili nyo, pwedeng A, pwedeng C. Number 12. Is DNA testing covered by the right against self-incrimination? Letter A, yes. Letter B, no. Question number 13. The mistake of counsel binds the client. Letter A, true. Letter B, false. Number 14. Means that the trial should be conducted according to the law of criminal procedure and the rules and regulations, and it should be free from vicious, capricious, and oppressive delay. Letter A, right against self-incrimination. Letter B, right to counsel. Letter C, right to be present in trial. Or letter D, right to speedy trial. Let's proceed to number 15. Can the right to appeal be waived? Letter A, yes, it can be waived expressly. Letter B, yes, it can be waived. I repeat, letter A, yes, it can be waived impliedly. Letter B, yes, it can be waived expressly. Or letter C, both are correct. Okay, once again, press 5 para sa mga huling dumating. Press 5 tayo. Your press 5 will only be accepted during live streaming. Okay, let's proceed to your knowledge about bail. Okay. 16. The security given for the release of a person in custody furnished by him or a bondsman condition upon his appearance before any court as required under the conditions specified by law. Letter A, subpoena. Letter B, recognizance. Letter C, bail. Or letter D, warrant. 17. The following are the different forms of bail, except letter A, corporate surety, letter B, property bond, letter C, recognizance, or letter D, cashier. Number 18. Where should one post bail if he hasn't been charged yet? Letter A, in the RTC of the place where he is in custody. Letter B, in the MTC of the place where he is in custody. Letter C, in the Court of Appeals. Or letter D, in the Supreme Court. Question number 19. Any domestic or foreign corporation licensed as a surety in accordance with law and currently authorized to act as such may provide bail by a bond subscribed jointly by the accused and an officer of the corporation duly authorized by its board of directors. Letter A, bondsman. Letter B, corporate surety. Letter C, cash deposit. Or letter D, recognizance. Number 20. Can an accused post bail even if he has not been formally charged in court? Letter A, yes, as long as the accused is under custody of the law. Letter B, no. Charge in court is a mandatory requirement. Letter C, it is subject to the discretion of the judge. Or letter D, none is correct. 21. If the accused is convicted in the RTC of an offense punishable from 6 to 8 years, is bail a matter of right or of discretion? Letter A, matter of right. Letter B, matter of discretion. Letter C, it is neither a matter of right nor a matter of discretion. Or letter D, it is either a matter of right nor a matter of discretion. 22. A person shall not be admitted to bail if charged with a capital offense. A, when the evidence of guilt is weak. Letter B, when the evidence of guilt is strong. Letter C, when the evidence of guilt is not enough. Or letter D, all of them. 23. The accused may be allowed to continue on provisional liberty during the pendency of the appeal, subject to the consent of the bondsman. Letter A, provided another bail should be given. Letter B, under the same bail. Letter C, under bail with higher value. Or letter D, none of them. 24. Upon custody and prior conviction, when the offense charge is not punishable by death, life imprisonment or reclusion perpetua. Letter A, bail is a matter of right. Letter B, bail is a matter of discretion. Letter C, bail should not be allowed. Or letter D, bail is not required. Okay, let's proceed to the last question. There is nothing inconsistent with posting bail and filing a motion to quash information. Letter A, true. Letter B, false. Okay, so natapos na ang ating self-evaluation sa araw na ito from question number 1 to question number 25. If you have not taken all these questions, you can back read and submit your answer not later than 10 o'clock tonight. Okay, so press 5 for the last time. Sa mga hindi pa nakapag-press 5, that will be a credit to those who are present today. Right, so let's have or let's end our streaming for today. Maraming salamat sa inyong pag-log in and see you again next meeting.